Hello to everyone, and thank you for joining us for this online seminar on victims' rights organized by PSIA. I'm Sharon Weill. I'm a professor of international law at PSIA, where I direct a clinic course, and at the American University of Paris. I'm very happy to introduce the two distinguished international lawyers who are with us here today. They both have a very long experience of working with victims of international crime, and they will give us insights on their work and experience. Reed Brody, legal counsel from Human Rights Watch, who since the 90s has worked closely with victims to initiate criminal legal actions against former dictators who committed war crimes and crimes against humanity, including Augusto Pinochet of Chile and Hissène Habré, the former president of Chad. Today, he works with victims of the former regime in the Gambia. Reed will discuss with us his experience of past and current cases. And Jeanne Sulzer is an international lawyer who has working experience in NGOs and international tribunals. She teaches at PSIA and the law school and is currently the head of the International Law Commission of the French section of Amnesty International. Jeanne will draw a portrait of the different legal mechanisms available to victims and the main challenges for victim participation. So in the coming half an hour, we will share our experience, 10 minutes each, and then we will open the floor for Q&A and your participation. So before giving the floor to Reed and Jeanne, I will start by presenting a book project which was recently published by Oxford University Press on one of the most important success stories of international justice, the president on trial prosecuting Hissène Habré. This trial happened as a result of an enduring collaboration of the victims of Habré's regime in Chad in the 80s, African and international lawyers and NGOs from Chad, Senegal, Europe, and the US, including Reed Brody of Human Rights Watch and Jeanne, who at the time worked with FIDH. A success story because after 25 years of struggle and different legal actions, Habré was finally convicted for crimes against humanity in Dakar, and he is currently in jail serving a life sentence. So this book is a result of a collaboration of three editors, Kim Sillinger, Kerstin Carlson, and myself, and our students. It started in 2016 when the trial of former president of Chad took place in the Special African Union-backed court established in Dakar, which prosecuted him for war crimes and crimes against humanity. So we went to Dakar to meet the different legal actors of this tribunal and the ones who made it happen with our students, including the students of the capstone course in PSIA. So at that time, we made interviews with judges, defense lawyer, the prosecutor, local NGOs, journalists, donors, clerks, the former prime minister, and the Ministry of Justice. And we decided that the best way to represent this trial will be to give the voice to all the different actors who were involved in this case and to tell their experience in first account. So the result is that we have 26 chapters of the different actors, starting from the first case that was brought almost 25 years ago with victims. We have chapter of victims, chapter of all the different actors. And in this way, we propose, in fact, a new methodology to study the trial, a methodology that put accent of the different actors and the different way that they collaborate, but also negotiated their place, and etc. And of course, Reed could give more detail about how this trial currently happened. And then the second part of the book It includes 18 academics, and here they comment the empirical experience of the actors that we have, and give their own analysis on different questions related to international criminal justice. So this is it about the book. I just wanted to add something that we could also discuss this maybe in the Q&A, is that this trial started as a civil law procedure. And in this trial, victims had a very important place, and they were able to be a party to the entire procedure, as the civil law procedure allowed. So the trial in itself was, for many aspects, also a truth commission, because many of the victims could give directly their testimony within the trial, and they were active and not passive in this sense, because civil law procedure give really an important floor for victim to take a part of the trial and to tell their own story. So perhaps we could go back to this later in the discussion and to understand why a civil law procedure is a good way to deal with international criminal justice for a victim point of view. So this is now all for my part, and I will give the floor to Reed to share his experience with us.
Great. Thank you very much, Sharon. And it's a wonderful book. I'm not sure if she's allowed to do this, but I will. I got my copy. Finally,
You
Sharon.
got it.
So, I've been working for 35 years on international human rights and justice issues in places as varied as Nicaragua and Haiti, and as Sharon mentioned, on the Pinochet case, on the Hissan Habre case, on currently working with the victims in Gambia, on the case of the former President Yahya Jammeh. And I want to speak really from my personal experience, but in particular, I want to focus on the role of victims as actors, as protagonists in international justice. When we were in London working on the Pinochet case, Human Rights Watch and Amnesty International were admitted as interveners in the hearings at the House of Lords on Pinochet's immunity. And one of the members of our team was a Chilean lawyer named Roberto Garreton. And Roberto, during the Chilean dictatorship, had worked as a lawyer at the Vicaría de la Solidaridad, defending victims of repression. And as it happened, by 1998, 25 years later, he was the UN Special Rapporteur on Human Rights in the Democratic Republic of the Congo. And he said to me something that always stuck with me. He said to me, you know, Reed, in Chile, there were 3,065 people killed or disappeared. And we have the names and the stories of everyone. I can tell you exactly what happened to every person. Now I'm the rapporteur for the United Nations on the Congo. I'm supposed to know more than anyone else in the world about human rights in the Congo. And I can't tell you if there were 1 million people killed, or 2 million people killed, or 3 million people killed. And I took away from that a very, I think, important lesson, which is that one reason why Pinochet had been arrested and was being prosecuted, and not Mobutu, the former Congolese dictator who had just died in exile, was because Pinochet's victims had names, they had stories, and they were known. And I want to look at 4 cases, or talk about 4 cases in which I think victims acted really as protagonists in the justice struggle. One is the genocide prosecution in Guatemala of the former dictator, Efrain Rios Montt. Another one is the case before a special court in Senegal of the former dictator of Chad, Hissène Habré. Another that I was involved in was the prosecution in Haiti of the president for life, Jean-Claude Baby-Doc Duvalier, and then the Pinochet cases in Chile and in Spain and the United Kingdom. And all of these campaigns shared some essential formal characteristics. It was the victims and the NGOs with them, rather than official institutions, who were the driving force behind the campaigns for justice. To a large part, it was the victims and their allies who actually compiled the evidence. These were cases that were brought before domestic courts, either of the country where the atrocities took place, in Guatemala and Haiti, or in foreign countries based on universal jurisdiction in Senegal and Spain, rather than in international courts. And as Sharon was talking about, I think is very important, the legal regime employed in these countries allowed victims directly to participate, either as partie civile under the French model, or acción popular, or querellantes adhesivos in Spain and Guatemala, rather than play just passive roles as witnesses in cases prosecuted by state officials. And I think that, when we look at these cases, we see, and one of my gurus, a professor in California named Naomi Roth Ariadza, who studied the effect of the Pinochet case, asked why cases like these, the Pinochet case, the cases in Argentina, Guatemala, and Habré, why they have a greater impact at a fraction of the cost of international justice. And one reason has to do, she said, with the agency of the victims and survivors. They were the driving force. In Guatemala, it was the sustained and determined efforts of the Mayan Indian communities over 30 years that kept the case alive. In a country where people get killed for fighting for human rights, the Indians, the Mayans and NGOs dug up graves, they told their stories, they pointed to the evidence. In the case of Haiti and Duvalier, when Duvalier returned to Haiti after 25 years in exile, he came back to a country where the powerful have always been above the law. But several magnetic, charismatic survivors filed what seemed at the time like quixotic complaints. Bobby Duval, a friend who counted 180 deaths in his cell in Fort Dimanche. The journalist Michelle Montas, who said that she refused to allow fear to return with Duvalier to Haiti. They filed cases and brought Duvalier to court. The Habré case, which is the subject of Sharon's book, was called one of the most patient and tenacious campaigns for justice. And it was driven by a man named Suleiman Gengeng in the beginning, a victim who, as people were dying around him in the jail cells, he took an oath from his prison that if he ever got out, he would fight for justice. And two of these cases, the Habré case and the Rios Montt case, went to trial, and the nature of the trial itself was determined by the victim's role. In the Habré case, for instance, the victims and Human Rights Watch and the other NGOs spent 13 years building the case, conducting hundreds of interviews, finding the files of the regime of police. But the coalition always insisted that any trial of Hissène Habré include crimes committed against each of Chad's victimized groups, the Muslims, the Christians, the Sahawas, the Hajarai, women. even the choice of who was to testify was made by the prosecutor in consultation with the victims. And the same happened in the Rios Montt case, where I was an observer. It was the victims and the NGOs who mobilized politically, who developed the evidence, and who also determined the outlines of the case. And I think what's important here is when we contrast it with many of the cases we see at the international level, where we find a distant prosecutor who is disconnected from what's going on the ground, who's not accountable to civil society, who can often be tempted to narrowly tailor a prosecution. In the beginning, for instance, the first cases brought by the ICC prosecutor in the Congo, where again, as millions of people were killed, and yet the prosecutor began by going after a handful of local warlords. And my colleague Pascal Cambele, a Congolese lawyer, very eloquently described how this was a betrayal of the hopes of Congolese civil society, that it was not what civil society expected out of the ICC. And when we, in both cases, Rios Montt and Hissène Habré, the victims had a greater role than witnesses. They were protagonists. And one of the proudest moments to me was when Souleymane Gengeng testified before the judge. And he began his testimony by saying that, you know, it was my stubbornness. I was fired from my job. I was threatened by Habre's henchmen. I went into exile, but that stubbornness paid off, and that's why I'm before you today, judges. And we heard the same thing in the Rios Montt trial. People who came and testified as witnesses, but also testified as protagonists. And I think when we look at these cases, we see that it was the role of the victims that created the political will for these cases to go forward. I remember being with Souleymane in Belgium. One of the reasons it took 20 years to get Hissène Habré before a court, 15 years, was because it bounced around. When Senegal refused to prosecute, the case went to Belgium, where the universal jurisdiction law permitted his trial. The universal jurisdiction law was attacked on all fronts and was repealed. But Souleymane came to Belgium. He spoke with the political leaders. He spoke with the Minister of Justice. He looked these people in the eye. He said, look, you know, he told his story about how he had taken an oath that he would fight for justice, and how Belgium had given him a lifeline for justice. And he said, and now you're telling me that you're going to take it back because you're repealing the law? And the minister and people like, no, Mr. Gengeng, no, we'll find a way to keep this case going. And that to me showed how important the victim is in the struggle for international justice. I mean, I compare that with some instances, for instance, when the former leader of Sudan, Omar al-Bashir, who is subject to an ICC warrant, was in South Africa, and there was a question over whether he should be arrested. He obviously should have been by the state party South Africa. And you heard from the prosecutor and you heard from diplomats, but the victims were absent. And so much of what has happened before the ICC in the past has been a struggle between North and South, between the world and Africa. But when it's a struggle between a man who came out of jail and is fighting for justice and the man who put him in jail, it's very clear where people are going to come out. Also, the role of victims is in a trial is essential in bringing out the evidence. I often said that working with Habre's victims, working with hundreds of active victims in Chad was like having hundreds of investigators. Everybody was working together. You would say to yourself, does anybody know somebody who worked in Habre's police? And somebody would, oh yes, my cousin was in Habre's police. Or do you know that? And it was like having an army of investigators. I think of, in particular, the question of sexual violence. We had spent a long time investigating the case, but I have to admit that we had not prepared the question of sexual violence because women didn't talk about it. But when people saw that Habre was actually going to trial, survivors began to tell their stories. But who did they tell it to? They told it to their lawyer, a Chadian woman named Jacqueline Mudena, who was representing them at trial. And even then, many of them were not sure that they wanted to come out and speak about it. And Jacqueline, during the trial in Dakar, Jacqueline Mudena, the lead lawyer, went back to Chad to convince some of the women to come and testify. And she was there in court, putting them at ease, giving them the courage to testify. It's hard to imagine that if these women had not felt part of what was going on, if it was not their lawyer who was representing the victims in court, that they would have felt comfortable doing so. I know that my time is running out, but the other thing I think is important is to see that victories that are achieved by women and activists there's an exciting component about them, which is that they are replicable. It was Pinochet's arrest in London that caused hope, that spread hope in Latin America, created a ripple effect throughout Latin America that people could challenge the status quo. But it's also what directly led Chadian activists to come to us. Delphine Jahaib, a Chadian activist, came to us and said, we want to do what the Chileans are doing. We have our own Pinochet. And as we prepared many years later for Habre's trial, we watched video clips of the trial of Rios Montt in Guatemala. And we saw things that informed the way that we were going to organize his and Habre's trial. And when Habre was convicted, the hope is that other survivors would be inspired by what Habre's victims did. And indeed, right after the verdict, we were contacted by victims of Yaya Jammeh in Gambia. And a number of the Chadian victims, and Jacqueline Mudena, their lawyer, and I, we went down from Senegal to Gambia, and the victims described what they went through. And it was very inspiring to see this kind of torch being passed as the Gambian victims looked at what the Chadians had done and said, we can do that too. So I will leave you with that. I wanted to talk about reparations and things, but we can save that for the questions and answers. And I know that Jeanne is an expert on that. But I just do want to close by saying that I think that the role of victims in the struggle for international justice is fundamental. And the ICC, if it wants to capture public support and the imagination of public, needs to do a better job, I think, of working together with victims in the fight for justice. Thank you.
Thank you very much, Reed. Of course, we could come back then to question, and you could continue to speak about reparation if you are willing, or other topic that we couldn't develop right now. So now I give the floor to Jeanne Sulzer. Please.
Well, thank you so much. It's great to be around this table, and very nice to know that there are a lot of people behind the screen and that we can have this exchange. I will try really to give some kind of overview of some of the challenges that victims' rights, that the rights of victims and challenges today, maybe building on more or less 20 years into the ICC, which happens to be 20 years also into the Pinochet arrest. So 1998 being the year when it all started, even though, of course, for that to happen, there needed to be all these victims working before to make it happen. As Reed was saying, I think hope gives hope, and when victims are being given space to participate, space to shape cases, miracles can happen. And it's quite, I think, what happened in the Habre case, where there was a number of elements that made it possible to happen. I would like to start by giving a few figures in relation to the ICC and to universal jurisdiction, just to maybe, figures are always good, and then maybe we can challenge those figures. With regards to the ICC, as you may know, one of the most important innovation with the ICC is that victims may participate, but they are not participating as real parties to the proceedings. And I think the name and the terminology itself is very illustrative of the limited scope of victims' participation, as they are called participants, not parties to the proceedings. However, one of the role that is really important is the role that they are being given, not only to victims, but also NGOs and victims association in being able to trigger the prosecutor through communications. It's called Article 15 communications. The numbers are quite interesting. The prosecutor in her latest report in December said that she and the former prosecutor together, Luis Moreno Ocampo, since the creation of the court received almost 20,000 Article 15 communications. That just shows that, of course, these communications are not only driven by victims, but I would guess, given that we don't know all of them, that most of them are victims and NGOs supporting them sometimes. Only in 2020, she received 800 communications. Out of these, more than half, actually 600, were apparently manifestly outside of the ICC jurisdiction. Still had 200 communications that came to either support ongoing investigations, and others that may actually end up in a new investigation on a situation that is still unknown to the court. So that kind of avenue that is given to victims, I think, is extremely important at the ICC. And brings a lot of hope. It's a new avenue for justice. The number of victims that are participating at the ICC that is something we could discuss, whether it's a large number or not, is around 10,000 victims are actually participating in ICC proceedings today, with 4,000 victims in the Ongwen case, whose verdict is tomorrow morning, actually. There are also victims that are participating in the earlier stage when the ICC is outreaching to the victims and making representation. This is how thousands of victims were making representations in the Afghanistan case. And then I will talk about what that means in terms of managing expectations. So just out of numbers, I think this is quite interesting. Now, looking at the other side of the coin, that is, of course, the shared responsibility with domestic courts, whether it's complementarity with the ICC or extraterritorial jurisdiction, universal jurisdiction. There are currently 18 countries that are prosecuting under universal jurisdiction legislations. There are 11 persons that are on trial. This represents around 30 countries or 30 situations that are being investigated in a third country. These universal jurisdiction, as we know them for most of the time, or have been triggered by victims. And if they are happening today, it's thanks to the proactivity of victims that have kept and documented for many years with a lot of courage the situation and have testified. Of course, what we see right now, and is very striking, is the increasing number of cases with regards to Syria that are going on in Europe, mostly in Germany, but not only in Germany, as well as in France and many other European countries. This just shows that whenever there is impunity, given that the ICC is not in a position to look into the situation of Syria because of the veto at the Security Council level, there are other avenues that are being looked, and universal jurisdiction is one. universal jurisdiction could be one of the way to start fighting against impunity with regards to Syria. Only in France, at the specialized unit, Crimes Against Humanity unit, there are over 70 investigations, 70 cases about many countries, with a majority of cases on Rwanda and a lot of cases looking also at Syria. I think what it shows is that it's both amazing how victims can have the influence of victims on the fight against impunity, how they can be the trigger, the actors, the protagonists, but it also shows the fragility of their rights. I think it's important to recall that it's not a grant, it's not a given, the rights of victims, that individual accountability, as we know it, individual has emerged from the Nuremberg tribunals, but the same, the recognition of the rights of victims did not go in parallel, and we had to wait until very recently to see international tribunals, I'm not talking really about domestic courts, to start recognizing the place and role of victims. Just as a reminder, the two first ad hoc tribunals, ICTY, ICTR, and even the Special Court for Sierra Leone did not provide any space for victims, nor did the Nuremberg Tribunal. Victims could only appear as witnesses. This was very much criticized, in particular at the ICTY and ICTR, where some of the victims felt that they were re-traumatized because they were not given a place per se, and they were asked and interrogated as witnesses. What it shows also is the increase, and Reed is such a good example of that, in the use of strategic litigation and using the law in a creative way, by NGOs, by victims associations, by victims themselves, just trying to find the right forum to bring justice. Using the law to advance human rights and to fight against impunity. We see this creativity going on a little bit everywhere. At the ICC, it's quite striking to see how victims and organizations are trying to push the boundaries of the jurisdiction of the ICC to get climate change litigation, land grabbing, to try to even get the Uyghur situation to the ICC. It didn't work this time, maybe it will work next time. The Rohingya jurisprudence, which Myanmar is not a state party, so there was no way to build on the ICC or to ask the ICC to investigate. Creative lawyers said, well, part of the crime is being committed in Bangladesh. Why don't the ICC look into Bangladesh? This is what the court is doing. It's not perfect, but it's just little steps that are interesting and that shows that creativity, strategic litigation actually do work when they're all put together. Reed said it, I think it's amazing to see as well that when victims are being given a space, then they can also shape the investigation, but they can also shape sometimes even the hearings and the trial, and I think the hearings of victims testifying when the fact that they had been raped in the Habre case is such an amazing example of these kind of moments that would just not have happened if the victims were appearing only as witnesses and if the victims had no legal representation and trust in the system itself. So these rights are fragile. They are fragile because they are being threatened. They are more and more being threatened. So as there are more and more cases, UJ and before the ICC, at the same time, there are more and more limitations to these. Why? Precisely because of the nature of the crimes. We're talking about crimes that are political in nature. They have a diplomatic sense to them. Sometimes they come in for universal jurisdiction cases as more of an obstacle to diplomacy between states. And so we've seen a number, and that was more 10, 15 years ago, of countries that had revised their universal jurisdiction legislation to close the door to victims, to make sure that they were not able to initiate proceedings anymore, because that's the key. The door to the cases is when you let victims initiate the proceedings themselves, and bypassing the prosecutor. That's where you get some cases that usually never passed that level. That happened in Belgium, it happened in Spain. It still is ongoing in France. Just as a reminder, in France, you can be a civil party for an ordinary crime. You cannot file civil party applications if you're a victim of crimes against humanity. So that's how absurd it gets when we're talking about these kind of crimes. Other obstacles that are still very current and problematic, the issue of immunity. Just very recently, the French Cour de Cassation ruled that there was immunity of jurisdiction for the crime of torture in the Guantanamo case of 2 French detainees. It's unbelievable that this can still be said when the Supreme Court of Germany said exactly the contrary a couple of days ago. The issue of immunity is still a very, very strong obstacles to the rights of justice to be heard. Other issues are more procedural, but the reality of victims' rights is also procedural, is before the ICC in particular, where there is an à la carte modality of participation that makes it extremely difficult for victims to read the court, to understand how the court works. Victims are being left in the middle of a system that is very complicated to know how to participate as participants before the ICC. Every single case has different modalities of participation, and therefore it's difficult for victims to navigate in the ICC. This lack of vision, sometimes from an even trial management perspective, is quite strong, I think, from the ICC perspective. The fact that, again, there's no clarity in the procedure, how victims can participate. This is also very true in mass trials, and I think here we can draw a parallel maybe with terrorism-related trials. And I think there's a lot of bridges to actually do between these mass trials, international crimes, and also terrorism-related. The trial that just happened, and Sharon can tell more about it, the Charlie Hebdo, where a very large number of victims participated, but mostly the upcoming trial of November, where there will be thousands of victims, issues of legal representation, issues of strategy, of trial management. My experience, and I think that's where I think it would be interesting to look closely at what is happening, what has happened at the ECCC in Cambodia, in the Habre case, and maybe for the future, is that victims are very often the victims themselves of trial management decisions, and they may pay the price instead of being recognized as victims. Yeah, so I'll stop there.
Thank you, Jeanne. I know there is so much to say, but we have here a really good question before us. So I think that what we could do now is to start with the question. I will perhaps propose one of us to answer to this, but of course we can be more than one person answering the question. Okay, so maybe we will start with Reed. So the first question was of Sofiane, and the question was the following. What do you answer to those who say International Criminal Court are simply the powerful judging the weak, and that's why a few African countries have been critical to the ICC?
Of course, I mean, there is a lot of truth, frankly, in that. I don't think we can expect that the institutions of international justice will operate outside of the sphere of political realities and of the correlation of forces. I mean, the African cases, I mean, each of the African cases is justified. I mean, there's not one of those cases that doesn't represent serious atrocities. The question is, why aren't other cases being dealt with? You know, I think as civil society, I mean, we have our job is to press these institutions and to raise the cost to these institutions of not seeking prosecutions in those cases. But it's not just the ICC. I mean, we have the same thing. You know, the two countries that had the widest universal jurisdiction laws, Spain, which was going to prosecute Pinochet, which has prosecuted Argentine torturers, Salvadoran torturers. When they started to go up against the United States or against China for Tibet or against Israel, the law was repealed. And the same thing happened in Belgium. The Belgian law, under which several Rwandans were and others are still being prosecuted, under which the Habre case was moving forward. I was in Belgium when Donald Rumsfeld, the Defense Secretary of the U.S., who we believe should be prosecuted and who we have tried to prosecute for torture, came to Belgium and said, well, you know, if NATO officials can't come to Belgium without being worried about being prosecuted, then we'll have to move NATO out of Belgium, and the law crumbled. So, I mean, we see these politics at work, and our job, I think, as activists, is to point it out, to raise the cost of not prosecuting cases that ought to be prosecuted. Obviously, the ICC's jurisdiction doesn't cover countries that haven't ratified. And many of the countries where we would want to see prosecutions either have not ratified the ICC statute or are, and therefore cannot be prosecuted even by a Security Council referral, because these countries either sit on the Security Council, or you know, Israel is protected by the United States, Sri Lanka is protected by China, North Korea is protected by China, Syria is protected by Russia and China. So it's true that there is a double standard, and we have to fight against that.
Jeanne, no? Okay, so I can continue to the next question, and then you will tell me who want to answer it. Do you believe that sexual violence has been enoughly addressed in the Habre trial, or could have been done better? So this is one part of the question. And the second is about reparation. So were there any reparation put in place and follow-up on all the victims involved in the trial? And if yes, who does the follow-up and support? NGOs?
Would you like me to answer that?
Yeah, you can maybe start with the sexual violence, and you could continue with the reparation. Is this okay?
Just go ahead, and I'll complement.
First of all, a shout out to Celine, who asked the question, who is one of the leading advocates for sexual violence victims in wartime and others, and whose work I admire greatly. Hissène Habré was convicted for overseeing a policy of sexual slavery and the rape of women. And he was actually convicted for the personal rape of a woman, Khadija Hassan Zidane, although that was dismissed on appeal because it had not been part of the indictment. And the verdict, I think, has been rightly hailed as a breakthrough for sex crimes prosecutions. But the irony, as I was talking about before, was that sexual violence was almost not part of the case at all. It was not included in the indictment. Even in, I have to say, in the Human Rights Watch 714-page report on Habré's crimes, there was very little about sexual violence, even though we had, we had women interviewing women. But I look back on this, and I say, how did we not deal with this? And as I mentioned, it was only really when it was clear to people that Habré was going to trial, that women felt, okay, it's worth it to talk about. And even then, you know, I think it would not have happened if it hadn't been for the relationship with Jacqueline. But you know, I learned personally, I learned from that, which is that you have to, you just can't wait for it to happen. You have to go out and make a point of looking for it. And I think you know, when the Habre case was coming to trial, and we scrambled actually during the trial with the help of Kim Seelinger and others, we got the charges amended at trial. And it was exactly the same thing that happened in the famous Akiyesu case in Rwanda, that, you know, sexual violence was not there. And then on the eve of the trial, stuff starts to come out and you have to change it. I think for me, the lesson was you've got, and in fact, I said this is a mea culpa, after the trial, I started looking at, you know, what should we have done? And Patricia Sellers, who many of you know, said to me, you know, you just have to look for it. And in my own defense, in our work in the Gambia, the first thing we did was look for sexual violence. And the first or the second report that we put out on Yahya Jammeh's crimes were about his personal policy of getting women, of using state resources to get women into his bed. And a very brave woman who had been kind of Miss Gambia, who had been raped by Yahya Jammeh, came forward. So I think clearly in the Habre case, it could have been done better from the beginning. And I think it's a lesson to us that you need to start looking at it from the beginning.
Yes, and perhaps if I can just add one small sentence, is that of course, as we can all imagine, victims of sexual violence has specific needs in question of also protection and how to express what they have been passing through because of sometimes pressure that you have inside your own family. So this is, of course, a very delicate balance that need to be specifically addressed in this kind of crimes. Jeanne, you wanted maybe to react for the question of reparation. What was the follow-up?
Maybe I can just say so Habre was convicted. The next day, the lawyers of the victims were called to make a request on what their claim for reparation. Of course, given the nature and the number of victims, there are 4,000 victims as civil parties. You can imagine the complexity also of getting the views of all the victims on the claim for reparation. At the end, what the reparation order is to the amount of 120 million US dollar or euros, US dollars, I don't remember, approximately. Well, in any case, it doesn't make much difference given that the victims haven't seen a cent for now. What is happening is that there is a very, very small amount that has been frozen from Hissène Habre's own property, but not much has been done at the investigation stage to seek the freezing of assets. A trust fund has to be set up, and this is something that NGOs are working on right now to push the African Union to actually set up this trust fund and make it happen and call for voluntary contribution to come and support the implementation of the reparation order. So this is so nothing has happened, and it puts a lot of pressure on the lawyers of the victims. It makes the situation very difficult.
And of course, always the question is who is paying, right? I mean,
it will be voluntary contributions mostly from the trust fund.
Okay.
Yeah, I would just add one thing. I mean, as Jeanne says correctly, I mean, the victims have not received a cent. In fact, Jeanne and I were communicating yesterday just directly about this question because these are people we work with. But I always felt in the Habre case that the victims would get reparations from the government of Chad. And when Hissène Habre was arrested in Dakar, Idriss Déby, the president of Chad, said publicly, he said, when this is all over, we will indemnify the victims. And and that's what I always felt. I mean, I never felt that, to be honest, that there was a real chance that in Dakar, the victims would get a lot of money. Habre doesn't have, I mean, stole tens of millions of dollars, but he probably went through most of it. And we'll obviously try to get what's left. But I don't really think that a victim's right to reparations for having been tortured or killed should depend on a criminal procedure against the perpetrator. It's the responsibility of Chad to just the same way it was the responsibility of South Africa, the responsibility of any government that does this to victims to indemnify them, whether or not they. I mean, what if the perpetrators die? I mean, it's the state that is really responsible here, and it's the state which needs to be indemnifying the victims.
Yeah, in this sense, I think we have to agree, because otherwise the reparation will be only for the one who participated in the trial. And of course, not all victims want to participate in a trial. It's a particular procedure. So indeed, the question to what extent reparations need to be linked to the trial itself. Okay, so I have another two questions that I will merge. And I would like to start with answering, and of course, after you could join. So the first, so the question was of Olin. Why have not we seen more normalization of restorative justice practices in international criminal justice institutions, like, for example, the South Africa? And the question of Julia was, what would you point out as the key changes in the ICC procedures that would strengthen the role of victims as active participants of trial? So thank you for this question, because this is really something that I have in my heart. And I want to give an example what we have now in Colombia. So I think that the Colombia process is a very interesting one, because this is really with the aim of merging the idea of, on the one hand, the criminal repression of perpetrator of international crime, and on the other hand, to have this entire process as a restorative process for the victim, who could all participate in this process to tell their own story, their own experience, and also to be able to have a kind of a recognition of the truth from the part of the perpetrator. So it's not only about a criminal struggle to put someone in jail, but really to work on admitting of the guilt and being able to establish a narrative. So, Olin, for your question, I think that we are moving to this direction, and I think that the trial in Colombia is the tribunal that is been created in Colombia following the peace agreement with the FARC is a good example for this. And a second example could be the terror trial that we are watching, at least here in France, because of the civil law procedure. So in the Charlie Hebdo trial, it was very strong. On the one hand, we have 1 month of victims that came here and told the story, established the narrative, and gave us, the audience, the details of what happened that we didn't know before also. So this was a very important role of the victim. And it took maybe 1 month, even more. And it was not about only prosecuting those people that we've been prosecuting here on this specific terror trial, which were also not the most important, responsible, because they died. But it was really with having the trial as a space for victims to be here, to be recognized, and to have the space to tell their story. And in a way, it is as important as the criminal trial. So I think that those examples, and in Colombia it's not by chance, it's also a civil law procedure, right? So this is why I started maybe with what I said at the beginning, and also the Habre case, is that through this, the space of the trial, we could achieve both of them if we will be attuned to the victims. But of course, at the same time, it's very important to be attuned to the accused rights. This is for sure. We cannot be, we cannot negotiate this place of the respect of the accused. And of course, it is a problem when you have 4,000 victims or 100 victims coming and participating in a trial against a person. So this is something to be think of. But we can find solution, and I think that today we have quite interesting example. So I don't know if one of you want to continue on this aspect, or we... Okay, so I continue now. So we have like 2 questions about migrants. So I will maybe read them both, and then we can see how we can answer those questions. So the one is of Sylvester. What response do we formulate to critics who claim that victims are not credible because their accounts seem too similar? Like anti-asylum rhetoric, some often criticize victims when their story seems too much, causing people to doubt their authenticity and claim that lawyers are crafting narrative. So the question was for you, Reed, but other can answer. What response do we have to stop this attack on credibility? So this was the first question on migrants, and the second was of Louise Anne. I was wondering what will be the legal framework mechanism that could be triggered when it comes to SGB crimes against migrants. So, Reed, would you like to start?
Well, I guess the answer to the first question is that, this is a trial is about finding facts. And if there's a defense lawyer and there's a judge and a jury, or potentially, and I mean, obviously, I mean, I think it would be dishonest to say that victims, are more truthful than other people, and do not, tailor their narratives to what they think people want to hear. I think this is human nature. It's particularly true when there's a power imbalance and people learn what the big man usually wants to hear. But that's what a trial is, what can I say? That is what a trial is supposed to determine, whether people are telling the truth. I don't think in a case of mass atrocities, it's not the individual testimony, it's the weight of testimony. I mean, I have to say, one of my experiences, every day in the Hissin Habre trial, I felt panicked because a victim who I knew had things to say was forgetting, they were getting dates wrong, they were hiding the fact that they had connections to a rebel group or whatever because they didn't think they were supposed to say those things. But that's what a trier of fact is supposed to be. And I think, I'm sure that I know cases in which migrants or asylum seekers say things because they understand that's what the asylum board wants to hear. There's no doubt that happens, and that's why you hire professionals to determine whether people are telling the truth. I think that's all one can say.
I wanted to maybe add at least the threshold in an immigration procedure and the threshold before a criminal trial is definitely different. We see, interestingly, a rise of cases that have been brought by because of 1F cases. These are the cases of persons that are not being granted protection under as asylum seekers because their testimony has been found to be where there's alleged commission of crimes. And these cases are being sent to, for example, the Specialized Unit on Crimes Against Humanity now on a systematic in a systematic way, and that has given really rise to a number of cases. So, yes, of course, there are some people, there are some narratives that are being built one way or another, either by victims who know that they should say a number of things, and also by persons that are trying to seek protection where they can't. But again, I think.
And as Jeanne said, the threshold and maybe the procedure, because in migrants' asylum court, you have only the narrative of the person. And of course, when you do a criminal trial, as you both said, many other evidence. So perhaps it's not comparable. Now another question, so about the question of how can we protect the migrants. So I can just refer you to one of our colleagues, also from PSIA, that he submitted, his name is Omer Schatz, and he submitted a communication to the ICC about the responsibility of European states, their direct responsibility in the policy in the Mediterranean of, not letting the boat arriving to Europe, and of course then that migrants that are there are many times the victim of sexual violence, of traffic, etc. So perhaps if this is an interest for you, Louise-Anne, you could check this communication that is now has been done in the ICC with Advocate Omer Schatz. Okay, so I can continue to the next question of Javier. So my question moved the discussion beyond victims' rights, and I wanted to know, do you have any evidence of the deterrence value of international prosecution for international crime? It's hard to prove, isn't it? Has there been a measurable decrease in atrocity crime which can be linked to the prosecution of these men?
I would say I'm not a big, I don't believe that there's a huge deterrent effect. But when Pinochet was his immunity was taken away by the House of Lords, I said that it was a wake-up call to dictators. And Human Rights Watch loved that quote. It was like very pithy, wake-up call to dictators. I don't believe it. I don't believe that Saddam Hussein and Milosevic, oh my God, what, I should like hide my torture things. But what it was it was a wake-up call to us. It was a wake-up call to victims. And that's what I was talking about before. And I think that the more this happens, the more it will happen. And the more people see victims organizing for justice and activists organizing, the more it will happen. And so and the more societies will be transformed. The more people can say, hey, you better watch out, or I'm gonna, we're gonna do to you what they did to Pinochet. I think that's what's exciting about international. We have not gotten to the point, absolutely not, in my view, that it is a deterrent. It is always on the table. I mean, now, no matter what happens, whether it's Syria or Myanmar, there's always the question of justice, and there's an expectation that there will be justice. And if there's not justice, it's a scandal that there's not justice. And so I think that has changed. But do I see people moderating their behavior in Africa because somebody in Latin America was prosecuted? No.
Okay, so thank you, Reed. We have 3 more minutes. So maybe instead of answering a question, maybe each one of us can say, of course, Jeanne, you could answer the question, but maybe if you want to add another final statement before the end.
The multiplicity of mechanism is striking to fight against impunity. whether it's supra investigators like the IIIM for Myanmar or for Syria, in trying to gather evidence and protect the evidence for future trials, whether it's positive complementarity in Central African Republic with national courts and complementarity. This is very striking. So there's a dynamic that indeed justice is part now of the discussion. Yeah.
Okay, thank you. Maybe I will say something, and like this, Reed, you will have the final word as our main expert. So from my point of view, maybe just to wrap up, because all the questions are also going to this direction, I think, of course, it's always important to have the political backup for those trials. It's really important to go alone against everyone, you know, it won't work. So, of course, we need to have a major political pressure. And once we could achieve this political moment when, you know, the law can go on, then I would recommend to think about new mechanisms that think creatively, again, as we could see in the Colombian case, because I think that we must include victims in the process, in the solution, and in the question of even what punishment to do. That this is also a part of the Colombian process, which is very interesting for me. Reed, last words for you?
No, I don't have, I follow up on what Jeanne said. I think what's very exciting is that there are so many things going on, whether it's, you know, the Syrian torturers being prosecuted in Germany, whether it's the ICC cases, you know, there is, I think, people, just as 50 years ago, people had the Universal Declaration of Human Rights in their hand. Today they have today they have justice in their hands. The idea that, you know, they don't have to take it, that they can turn the institutions around against the people who are oppressing them. We have a long way to go. Unfortunately, most people still get away with mass murder. But the fact is that now it's always a struggle. Now people are document. I mean, every day now, people. I was talking to somebody from Nicaragua today, you know, where she was saying, what we just have to do now is document everything, so that one day we'll be able to use it. And I also think I'll close with something that Roberto Garraton said to me in London, the Chilean. He said, you know, Reed, when I was at the Vicaria, we filed, whatever it was, 1,264 habeas corpus cases on behalf of prisoners. And he said, you know how many succeeded? I said, no, Roberto. He said, 0. And I used to ask myself, why am I doing this? And today, as I'm in London and we're discussing whether Pinochet should stay in jail, now I realize why I did it. And, you know, so I think we see people all over the world preparing, documenting, videoing, Bellingcat, video, everything, so that justice can happen. And I think that's the most exciting thing.
Thank you for this optimistic ending. Thank you very much for everyone, and thank you for the excellent questions of the students, and thank you for PSIA for organizing it. And bye-bye.
Thanks.
Bye-bye. Thank you.
Bye.
Bye. Bye, Reed.